now I want to welcome all the fellows from International Academy of Matrimonial Lawyers. Welcome to Argentina, welcome to my country, and enjoy the Hague Symposium. We'll start now first with Carolina Pedreño, that will talk about the Hague Convention, international principles.
Good morning, everyone. My name is Carolina Marín Pedreño. I'm Spanish. I'm a Spanish lawyer, and I'm also a solicitor in England. I'm currently practicing in London, and I specialize in minors' abductions with country signatories of the Hague Convention and non-signatories of the Hague Convention. I'm here today to talk about the principles of the 1980 Convention on International Abduction of Minors, civil aspects. But before we dive into the principles, I would like to address shortly the number of countries that have signed the Convention and why I especially believe that it's been a success for minors' protection. I'm talking about the enforcement of this Convention worldwide. At present, there are 90 signatories of the Convention. Unlike other conventions, the Hague Convention is particular in the regard that a country that has signed in the past can decide whether they can accede to the countries that sign afterwards. For instance, the 1996 Convention on Minors' Protection, unlike the Hague 1980 Convention, provides that countries that signed before, for instance, Argentina signed before Kazakhstan, they have a 6-month reserve to determine whether they want to adhere to that country or not. I believe that this is the basis for this because it is a legal instrument where mutual trust is of the essence between signatory countries. In addition to that, the fact that every country has a central authority where cooperation and communication are vital for the operation of this convention, I believe that this is also another key element of the success of this convention since it was first signed. Here's a picture of the world map with all the countries that have signed the Hague Convention. And we see, for instance, that Argentina has decided not to adhere to Kazakhstan, but has no other reserve in connection with any other country. Unlike, for instance, England and Wales, that have been a little bit more selective and has had more reserves to countries that have signed after them. For instance, in the north of Africa with Morocco and also with Russia. But Russia signed the 1996 in June with Nicaragua as well. For you to have an idea of the main basis of the Hague 1980 International Convention, that mutual trust that you need to have with other signatory countries in order to achieve the purpose, which is immediate return of the minor of the country of habitual residence. As I said, the purpose is the immediate return of the minor, and the basic principles underlying the convention are reintegration, an attempt to have the minor be reintegrated to the environment where they were abducted. This mutual understanding for many purposes, that the fact that a minor is being substructed or held in an environment that is alien to them, a different language where they need to make no friends, they need to go to a new school, and first and foremost, where they don't have a relation with the other parent, with the parent that is still in the country of habitual residence, the left behind parent. The basic principle is prevention. We attempt to prevent, to have the child immediately returned. With that, we want a parent to be prevented from abducting or holding a minor in a country other than the country of habitual residence, in the belief that they may have a certain advantage when it comes to procedural law. As for other basic principles, the text of the convention refers to the best interest of the minor. The best interest is what the tribunal must take into consideration when deciding any of these cases. They do not define the best interest of the minor in the same way as they do not define custody rights or habitual residence. Why is that? Why did the lawmaker choose to go that way? First of all, to prevent the procedure from lengthening unnecessarily when an inquiry needs to be made into the best interest of the minor. And also because we don't know whether we are talking about the best interest before the abduction or after the abduction or the long-term best interest of the minor. And especially, the rationale is that the country where this inquiry may be made in the best manner is the country of habitual residence of the minor. Swift return or immediate return, immediacy. What do we understand by swift return? What do the signatory countries understand? Article 2 refers to the contractual duty of every signatory country to use the best suited procedure to guarantee swift return. The European Union members have European regulations known as Brussels II that also emphasize on swift return. There is an article whereunder member states impose a 6-week limit to settle these cases, and central authorities also have the power to demand the courts why a certain procedure is taking more than 6 weeks. Here is when we're talking about cases between different members of the European Union. I have chosen to include certain statistics for us to see, in connection with different signatory members of the Hague Convention, how long it takes since the procedure commences until return is ordered. As we see, Denmark has an average of 44 days. Then we have Chile with 146 days, Argentina 225. So SWIFT is interpreted very differently from country to country. Every signatory country applies a different procedure. America 227. We see that Paraguay is the one with the worst record with 646 days. So when it is determined that a country needs to be returned to the country of origin, and when I say country of origin, I mean the country of habitual residence, if it is decided after 2 years that the minor's been illegally held in a different country, the best interest of the minor, reintegration, the basic principles of the conventions have been lost. The language of the convention also makes reference to defenses. Defenses are of an extraordinary nature, and they are limited, they are very few. And basically is that the child is not a habitual resident in the requesting state, that the applicant has no rights of custody, that the child has already been settled or integrated to the new environment. There is a very interesting case settled by the Supreme Court of the United States of America on settlement, because there's doctrine that states that the time during which one of the parents has been in hiding after an abduction should be computed as time during which the child is settling, but there's doctrine to the opposite effect. Then there's Article 13, that is failure to exercise custody rights, consent by omission, when the child, if returned, is going to be exposed to grave risk of harm, and opposition by the child. And 23, which is the protection of human rights and freedoms, that is the one that is least applied. Article 20 has been rarely invoked. It's very exceptional. I'm only aware of one case with Zimbabwe, where a child was not returned to Zimbabwe because it was at a time during which the country was facing serious social and political problems. More statistics. In 2008, with what frequency, what was the defense most often invoked? That is 13.1, which is serious harm or an intolerable situation. That is the one that is invoked most frequently. Then minors' objections, and also above that, the child not being a habitual resident of the requesting country. And to wrap up, I have that defenses that were most applied in each country. For instance, in Argentina, there was only one case where the child was not a habitual resident of the requesting country. Then there's something very curious about Mexico. In Mexico, that defense based on minors' objections is the one most often considered by the courts when it comes to admitting these defenses and ordering the not return of the minor to the country of habitual residence. With that, I conclude, and I really hope that it's a good starting point for the responses. Thank you for your attention.